Namaskar students. Hope you are hale and hearty, taking care of your health and your studies. Before we begin today's session, I would like to ask you a very simple question. From the Constitution of India, which is that part which is very essential for every citizen of India? Probably univocally you would say it's the fundamental rights. Yes, fundamental rights play a very important role in the life of every citizen of India. Along with the fundamental rights, we also have certain fundamental duties which help us, our country, to grow. In order to keep the functioning of the state and with the changing time, in order to make sure that the state functions to the best of its ability. Yes, that is our topic of discussion today. Chapter number 4 from your books Social and Political Life of Grade 8. The name of the chapter is Understanding Laws. Let's get going. Law commonly refers to a system of rules created and enforced through social or governmental institutions to regulate behavior. With its precise definition, a matter of long-standing debate, it has been previously described as a science and an art of the justice. State-enforced laws can be made by a group legislature or by a single legislature, resulting in statutes by the executive through decrees and regulations, or established by judges through precedent, usually in common law jurisdictions. Private individuals may create legally binding contracts, including arbitration agreements that adopt alternative ways of resolving disputes to standard court litigation. The creation of laws themselves may be influenced by a constitution, written or tacit, or the rights encoded therein. The laws shape politics, economics, history, and society in various ways and serves as a mediator of the relations between people. Legal systems vary between countries, with their differences analyzed in comparative law. In civil law jurisdiction, a legislature or other central body codifies and consolidates the law. In common law systems, judges make binding case law through precedent, although on occasion this may be overturned by a higher court or the legislature. Historically, religious law influenced secular matters and is still used in some religious communities. Sharia law, based on Islamic principles, is used as the primary legal system in several countries, including Iran and Saudi Arabia. So, talking about the characteristics of a good law, in order for a law to qualify as a good law, it must have the following features. First and foremost, the law must be in the interest of people. All good laws must be in the interest of people whose lives and behavior they seek to control and regulate. Here, the law must be able to satisfy the needs of the people. Any law that is not in interest of the people is not considered a good law. Moving on, the law must not discriminate. This means that the law must apply to everybody that falls under it in an equal manner. Nobody should be above a good law. A good law does not discriminate. In the eyes of a good law, everybody is equal. For example, a billionaire politician should be equal in the eyes of a good law, just like a pauper. A good law is no respecter of person's status or position in the society. A good law must be reasonable. By being reasonable, a good law should not be one that is too harsh or rigid, such that it is very difficult to obey. and sanctions associated with flouting or disobeying a good law should be reasonable or should equal to the gravity of the disobeyor's deeds or actions. This is what is meant by the statement, a good law should be reasonable. A good law should be able to be enforced. An unenforceable law cannot qualify to be a good law. Before any law can be said to be a good law, then it must have the capability of being enforced. When a person flouts a good law, the person should be able to be sanctioned appropriately in order to deter others from also breaking it. A good law should be made known to the people who are going to be ruled by it. All good laws are publicized in order that the people get to know about it. Since ignorance of the law is no excuse, a good law must be made known to the public so that the public is aware of that there is such a law in existence and the consequences of breaking the law. Laws should not suppress the people. Any law that seeks to suppress or intimidate the people is not a good law. So, do laws apply to all? Let's see. As there should be no arbitrary exercise of power in independent India, therefore, the members of the Constituent Assembly instituted several provisions in the Constitution that would establish the rule of law. All persons in independent India are equal before the law. All laws apply equally to all the citizens of the country, and no one can be above the law. That means the law cannot discriminate between persons on the basis of their religion, caste, or gender. Any crime or violation of law has a specific punishment. In ancient India, there were innumerable and overlapping local laws which did not apply equally to all. The punishment of the same crime varied depending upon their caste background, with lower caste being more harshly penalized or punished. Members of the Constituent Assembly were agreed there should be no arbitrary exercise of power in independent India. To establish a law, they instituted several provisions in the Constitution. The British colonists introduced the rule of law in India. Historians have disputed this claim as the colonial law was arbitrary. The Indian nationalists played a prominent role in the development of the legal sphere. The British law of the Sedition Act of 1870 set a perfect example of the arbitrariness. Under this act, a person protesting or criticizing the British government could be arrested without due trial. Now, how this entire act came into being? The section related to sedition initially had its place in the code as Section 113. When Thomas Babington Macaulay drafted the Penal Code in 1837, however, for reasons unknown, it was omitted from the actual code. It was finally added in 1870 on the suggestion of James Stephens. At the time handling legal issues in the colonial government of India due to increasing Wahhabi activities and fearing that Muslim preachers would incite religious war in the Indian subcontinent. The Raj introduced this section under the title Exciting Disaffection. The then British government in India feared that Muslim preachers on the Indian subcontinent would wage a war against the government, particularly after the successful suppression of Wahhabi or Waliyullah movement by the British. The need was felt for such law. Throughout the Raj, this section was used to suppress activists in favor of national independence, including Lokmanya Tilak and Mahatma Gandhi, both of whom were found guilty and imprisoned. The section kept drawing criticism in the independent India as well for being a hindrance to the right to free speech. Moving on, Indian nationalists began protesting and criticizing the arbitrary use of authority by the British. They began fighting for greater equality and wanted to change the idea of law from a set of rules that they were forced to obey to law as including ideas of justice. So by the end of 19th century, the Indian legal profession began emerging and demanded respect in colonial courts by using laws to defend the legal rights of the Indians. Indian judges began to play a greater role in decision making. With the adoption of the constitution, laws for the country began to be made by the representatives. Every year, representatives pass new laws as well as revise the existing ones. If we closely look at certain legislations being carried out in the last 15 years, we would see that the Hindu Succession Amendment Act of 2005 was a revolution. According to this law, sons, daughters and their mothers can get an equal share of family property. It came as a revolution. In 2019, many legislations brought breath of a fresh air, like the Jammu and Kashmir Reorganization Bill in 2019. The bill was introduced on August 5th by Minister of Home Affairs Mr. Amit Shah in the Rajya Sabha. It aimed to reorganize the state of Jammu and Kashmir into Union Territory of India by revoking Article 370 in the state. After the bill, all provisions of the Constitution as amended from time to time without any modification or exception shall ask to the state of the JNK. The Motor Vehicle Amendment Bill in 2019 brought serious changes. The bill sought to amend the earlier Motor Vehicle Act of 1988 regarding road safety. It was introduced in the Parliament by Minister of Road Transport and Highways Shri Nitin Gadkari ji. The Act provides a list of penalties regarding violation of road safety rules as well as standards that have to be maintained. The Code of Wages 2019. This bill aimed to regulate wage and bonus payments of all the employments where it's industry, trade or manufacture. It was introduced in the lower house of the Parliament by Minister of Labour Santosh Gangwar on July 23rd. It sought to regulate 4 earlier laws. The Insolvency and Bankruptcy Code Amendment Bill of 2019 introduced to amend the earlier law to provide a time-bound process for resolving insolvency in companies as well as individuals. It was introduced in Rajya Sabha by the Minister of Finance Srimati Nirmala Sitharaman on July 24th. Citizenship Amendment Bill 2019. The bill aimed to grant citizenship to members of Hindu, Christian, Sikh, Buddhist, Jain and Parsi communities who have come to India from Pakistan, Bangladesh and Afghanistan till 31st December 2014. The government has also said that this new act will be followed by the National Register of Citizens. So talking again about Hindu Succession Amendment Act of 2005, according to this law, sons, daughters and their mothers can get an equal share of family property. So how do new laws come about? The Parliament has an important role in making laws. An important role of Parliament is to be sensitive in the problems faced by the people. The issue of domestic violence was brought to the attention of Parliament and the process adopted for this issue to become law. The Protection of Women from Domestic Violence Act 2005 was implemented to protect women from being abused and injured by men. In the same manner, to the rescue of Muslim women, an act of 2019 under which the Muslim Women Protection of Rights on Marriage Act 2019 is an act of Parliament of India criminalizing triple talaq. In August 2017, the Supreme Court of India declared triple talaq, which enables Muslim men to instantly divorce their wives to be unconstitutional. So, going back to domestic violence, the injury or harm caused by an adult male to his wife, the role of citizens is crucial in helping Parliament frame different concerns that people might have into laws. From establishing the need for a new law to its being passed at every stage of the process, the voice of the citizens is a crucial element which makes the work of Parliament more accessible and transparent. Now, let's talk about some unpopular and controversial laws. Sometimes a law can be constitutionally valid and legal, but it can continue to be unpopular and unacceptable to people because they feel that the intention behind it is unfair and harmful. People might criticize the law, hold public meetings, write about it in the newspaper, report to the TV news channels, etc. In a democracy, citizens can express their unwillingness to accept repressive laws framed by the parliament. When a large number of people begin to feel that a wrong law has been passed, then there is pressure on the parliament to change it. If the law favors one group and disregards the other, it will be controversial and lead to conflict. People who think that the law is not fair can approach the court to decide. The court has the power to modify or cancel laws if it finds that they do not adhere to the constitution. In India, role of citizens does not end with electing representatives. They also analyze the work done by MPs and criticize their actions if needed. Therefore, it is stated that people in a democratic country have the right to protest against the unjust laws. We have three types of law. Criminal law. It is to protect people from deliberate or reckless harm. Laws directly written to limit people's behavior to keep society orderly and safe. Next is civil law. Civil law is to find remedies when two people come into conflict when there is no law broken. Last but not the least is public law. Under public law is to guide people's actions in order to be fair and equitable to everyone. We have constitutional law, administrative law, and statutory law. So, in the end, we can just say that it is the extent, involvement, and enthusiasm of people that helps Parliament perform its representative functions properly. A good law becomes a great law when the citizens abide it with all their heart. I hope this was a fruitful session for you. So let's try to analyze what we have learned out of it. So on your screens you can see a statement and there are 4 options to it. You have to pick the correct option. So when did the Protection of Women from Domestic Violence Act come into effect? Was it 2006, 1990, 2001 or 2005? Yes, it is 2005 when the Protection of Women from Domestic Violence Act came into effect. Moving on, a bill finally becomes an act after the assent of President, Prime Minister, Supreme Court or the Speaker. A bill finally becomes an act after the assent of His Highness the President of India. When was the Sedition Act passed? Was it in 1870, 1860, 1919 or 1858? It was passed in 1870. Very good. Abuse of the women includes economic abuse, sexual abuse, verbal abuse or all of these. Yes, any kind of abuse, be that economic abuse, sexual abuse or verbal abuse, become a part and parcel of abuse to the women. So the answer is 4th, all of these. So now you can see 2 boxes on your screens. You have to match the statement with the correct box. So the Sedition Act, it was passed in 1870. Protection of Women from Domestic Violence Act, It was passed in 2006. RALT Act. RALT Act was passed in 1919. Controversial laws lead to conflict. So let's do some fill-ups. All persons in independent India are dash before the law, equal before the law. The colonial law was arbitrary. Indian judges began to play a greater role in making decisions. The role of citizens is crucial in helping the parliament frame different concerns that people might have into laws. In order to make a nation great, it's a two-way process. When the laws are made, we should abide by them religiously. Together we can and we will make a difference. Yes, that should be the motto all of us should follow. With more videos, we'll be back. Till then, stay safe, stay healthy, and keep studying. Namaskar.